Okay, this is the third article of hundreds more to come, serving others as an international consultant of economic and government choices. This is filing in the wrong Texas County Courthouse to price fix deeds. When you go to filedevidence.com, Exhibit 3 once again proves it was filed in the wrong courthouse to create not 7 farms and ranches, but 3 imaginary farm ranches, 3 more imaginary farms and ranches, when my bank filed and recorded fraudulent government and or loan documents in the Texas courthouse. Now this relates back to Exhibit 1, of course this is 3, Exhibit 5, 11, and 12. And these are all like-kind infractions. And the Texas Bank's government confiscation of all of my 7 farms and ranches against the bank's small amount of indebtedness. Once I found out by a rumor that I was being foreclosed on, and the way I found out about it, I was donating land to a school, and the school board president said, "Oh, Jerry, by the way, that land you're donating to us, do you realize it's posted on the courthouse board for foreclosure?" So anyway, this forced me to hire lawyers and file for Chapter 12 bankruptcy protection to salvage at least part of my excessive equity. Otherwise, the bank would have taken all 7 farms and ranches on the courthouse steps, and I would be out. So I was forced to file for Chapter 12 bankruptcy court in March of 2015, and I have fought the court system by providing the burden of proof all the way through April 2022, seeking, pursuing, and exhausting my constitutional 14th Amendment rights of equal protection of the law. And this is an update on all of the courts that I went through, and this is an update as of the last April 2022 ruling. And this is an update of all the courts that chose to exercise the court's constitutional checks and balance rights to create, inflict, and allow new case law changes. This is what our forefathers' constitutional framework intended. And in spite of my filed evidence, burden of proof, and in direct defiance of the current laws, these courts' landmark decisions favored the preferred absolute power. And they allowed and did not enforce the bank's multitude of law violations. I appealed it, and without a hearing, the appeal court endorsed the new case law changes. And then it went into a state court, and they ruled new case law changes in defiance of the federal bankruptcy court's rules of procedure. And I went to the Supreme Court, and as of June 12, 2019, the Supreme Court's clerk found no controversies and wouldn't let me go any further in the Supreme Court to endorse all of the new case law changes from June 12, 2019 and back. And then going through some other courts, and finally I re-petitioned the original bankruptcy court where I was forced to file Chapter 12 protection and asked them to enforce their own ruling of discharging my debts as debt-free. And without a hearing, on April the 8th, 2022, ruled and dismissed Artho versus Bank/Lawyers cases, endorsing and judicially reconfirming each and every count, each and every violation of law as that of being new case law changes from May of 2012, when the first illegal loan document was filed, and from this day forward. So now anyone can use these new case laws to persuade judges and juries in their favor. Because constitutionally, we respect the Constitution, and we respect the courts' rights to create, inflict, and allow new case law changes. Somebody's got to make the call, and this is what they've allowed. Now, in the bankruptcy court, the handbook of the Chapter 12 standing trustee, the trustee is to report suspicious criminal activity and suspicious violations to the United States Attorney. And the standing trustee should bring motions of insubordination against the bank for filing the fraudulent government and loan documents. And in the bankruptcy fraud, this includes anything relating to bank fraud. And the duty of the standing trustee is to detect and prevent fraud and abuse by debtors, creditors, or other parties in any Chapter 12 case. And the standing trustee is to report those matters to the United States trustee. Now, which part of the government and loan documentation fraud the standing trustee didn't suspect is beyond me. But the filed evidence proves beyond a shadow of a doubt this is what occurred. Of course, under international consulting of economic and government choices, any new case law type changes like this in any nation's judicial, by any nation's judicial officials, when those judicial officials disregard their constitutional oath of office and disregard any tax-paying commoner's constitutional rights, to government confiscate any investor's sustainable long-term investments, and their landmark decisions favored the filed and recorded fraudulent government and or loan documentation to favor any nation's absolute, powerful, unsustainable, short-term, ill-gotten gains. The filed evidence in filedevidence.com proves beyond a shadow of a doubt what was filed in the courthouses and what was filed with the court. This will in fact immediately destroy any investor's sustainable long-term investments, as it did mine and as it will yours under new case law changes. This destroys the trust of any nation's judicial system. For I was like everybody else. I thought, well, I have a constitutional 14th Amendment right. They wouldn't rule against that. While this will quickly destroy any nation's economy. This is bad policy.